The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Good afternoon. We have two cases that will be submitted. Those cases are Alex Westra versus Iowa Department of Transportation, and the second case is Cheryl Albaugh versus the Reserve. We'll first hear the arguments in Westra versus the DOT. Mr. Lindholm.
Thank you and good afternoon. May it please the court, counsel. As far back as 1902, the Iowa Supreme Court stated, quote, "A party to a suit can gain nothing by virtue of violence under the pretense of process, nor will a fraudulent or unlawful use of process be sanctioned by the courts. In such cases, parties will be restored to the rights and positions they possessed before they were deprived thereof by the fraud, violence, or abuse of legal process." Stating State versus Height from 1902. I stand before you today representing Mr. Alex Westra. Mr. Westra had his license revoked pursuant to the implied consent statutes. He had that license revoked after a Department of Transportation officer exercised his authority and stopped his vehicle. The problem here is that the DOT officer who stopped Mr. Westra lacked legal authority to effectuate the stop. The department's going to stand before you and say it doesn't really matter. I'm saying it does. And I'm asking this court to restore Mr. Westra's driving privilege because of the unconstitutional and unlawful actions of the DOT
Well,
officer.
were they unconstitutional or just unlawful?
They're both.
There wasn't a problem with the stop per se as far as whether there was reasonable suspicion. Your client had committed a traffic violation by stopping on the interstate, right?
I won't concede that. No, I don't think this record's clear enough to address that. That wasn't the issue that was raised lower.
But it's not disputed, let's put it that way.
I am disputing that. It's not this issue. But to answer your question, I think the heart of your question is are we dealing with a statutory issue or a constitutional issue? I think it's the heart
that
of your
is the
question.
heart of the question. In other words, is it that the DOT officer lacks statutory authority or that the stop violated Article 1, Section 8?
It's both. And let's start with this proposition. First of all, any action by an agent of the state is unlawful or presumed unlawful and unconstitutional unless it has a warrant. There's no disputing that. There was no warrant here. There's no disputing that. So then we have to try to fit that officer's conduct into some exception to the warrant requirement. When we have an officer whose authority is limited by law and that officer acts outside that limitation, that's presumptively unreasonable. Otherwise, that law has no basis. The same would be true as if the officer said that there was a statutory violation for a rule of the road and there wasn't one. He says there is, there isn't. He acts beyond the parameters of that statute in effectuating the stop. So to the extent that the statute granted him authority, that is true. He acted beyond that statutory authority. But the fact that it contains constitutional undertones and underpinnings, it is a constitutional issue. So I want to frame this issue and have you realize what kind of box Mr. Westra was in as a result of this conduct by the DOT officer. Iowa Code Section 321J 13 sub 2 indicates that only certain issues can be raised in an administrative license suspension hearing, including reasonable grounds to believe whether the person was intoxicated, whether they took the test, whether they refused the test. It does not specifically explicitly allow the challenge to unlawful police activity that resulted in the stop and detention of the person. 321J13 sub 6, on the other hand, provides a statutory remedy for somebody to challenge the stop of the vehicle as long as there's a parallel criminal proceeding. The dichotomy here is that somebody who has a criminal charge filed against them gets the constitutional protection. Somebody who doesn't have a criminal charge filed against them does not get that constitutional protection and that available remedy. That's the box that Mr. Westra is operating out of. And because of that box, he specifically asked at the administrative hearing to rescind the license revocation and have the hearing officer determine whether or not the DOT officer exceeded the lawful scope of his authority and violated his rights. And I don't think there's much argument in light of this court's holdings under Werner and Riley that
When they stopped him, did they file a complaint and then not file an information? I mean, did they file something?
they filed a charge for an open container as a simple misdemeanor. They filed a traffic ticket. That was it.
They didn't file a complaint of OWI to be followed by an information, and then just failed to file the information?
You know, I don't know the answer to that. I'm not sure if it's in the record. I don't know if they actually formally filed an initial preliminary complaint, but I know for a fact they did not file a trial information, which therefore precluded my ability under 321J13 sub 6 to attack this and provide him the statutory remedy under that code
Would
section.
that make a difference under our Tager case, though, if they filed the preliminary complaint and then they just didn't follow through with it, which precluded your client from contesting the stop?
Well, I think in Tager, the issue was the filing of the trial information, and that then triggered the ability to file a motion to suppress. They did dismiss it. I don't think you do have a Tager situation exactly, because if only a preliminary complaint is filed, I don't have the ability to file a motion to suppress and seek a judicial determination that the evidence is inadmissible because of a violation of the law. I don't have that ability. There's nothing in the rules that allows me to attack that preliminary complaint. I would have to wait until the filing of the trial information. So in light of this court's holding in Werner, I really don't think there's much dispute that, in fact, this DOT officer did not have the authority to effectuate the stop in this case. So the question becomes is what remedy and how do we provide Mr. Westra with a remedy? And my solution to that is we apply the exclusionary rule under the Iowa Constitution. Under Article 1, Section 8, as the brief sets forth, there's different purposes for our exclusionary rule under the Iowa Constitution. One is obviously deterrence, one is to provide a remedy for a wrong, and one is to promote the integrity of the judiciary. The department has relied heavily on the holding in Westra, or Westendorf, excuse me. Westendorf was a Fourth Amendment case. It wasn't an Article 1, Section 8 case, and it simply dealt with the deterrence prong of the Article 1, or I'm sorry, of the Fourth Amendment. It did not deal with any of the other purposes for which this court has established.
I agree with you. Westendorf doesn't resolve Article 1, Section 8. Do you agree with me, then, that a necessary linchpin of your argument is that the stop of your client has to have been unconstitutional and not merely unlawful?
No, I don't agree with that. I know where you're wanting to go, Judge. I know where you're wanting to go because of what you wrote in Werner. I'll give me an opportunity to address that, if you may.
I don't know where I want to go, so if you could, you're welcome to enlighten me when you get a chance.
I know where I think you're directing me to this line of inquiry. I'll put it that way. I don't think it matters whether it's a statutory or constitutional violation. To my knowledge, this court has never distinguished the exclusionary rule's applicability, whether it's a constitutional exclusionary rule or a statutory exclusionary
Well,
rule.
here's where I think it does matter, and the reason is this, is you do have a statute that seems to, on its face, limit the issues that can be raised in a license revocation proceeding. That statute says these are the issues that can be raised. And if we are only talking about that statute allegedly in conflict with another statutory violation, and that statute says, limits the numbers of issues that can be raised, then it seems to me you may have some difficulty there. If it's a statute that's at war with the Iowa Constitution, then that's a different situation, right?
Yes, and let me take an opportunity to address that. So, as it relates to a statute being in conflict with the limitations of what can be raised in an administrative hearing, Iowa Code Section 804.20 had that same problem. Yet this court went ahead and applied the exclusionary rule under Iowa Code Section 804.20 to license suspension proceedings, even though the statute did not allow such issue to be raised in driver's license suspension proceedings. So to the extent that there's a statutory violation, I don't see how that differs from the application in this case to what this court did with respect to Iowa Code Section 804.20. As it relates to your question concerning the constitutionality, again, Judge, if we have a situation where we have statutes that limits an officer's authority, say, for example, the roadblock statutes. If the roadblock statutes are violated, I still raise a constitutional issue, right? If the officers do not set roadblocks up in Iowa in accordance with the statutes, I still raise a constitutional issue, as I should, because it's the violation of the statute that creates the constitutional problem. And I don't see how that is any different than the present situation.
Let me take you back to the 804.20 situation. We adopted that exclusionary rule before Westendorf was decided, right?
I believe so, correct.
Right.
Yes.
So then we came in Westendorf and said, these are the issues that you can raise. Now, evidently, at that, we had already said 804.20 was an additional issue that you can raise, but we limited the issues that can be raised in Westendorf. And then it seemed like the legislature amended the statute and more or less, subject to the amendment, agreed with our approach. So why should we reach back to some old 804.20 precedents that preceded Westendorf?
Well, Westendorf didn't limit the issues that could be raised carte blanche in administrative proceedings. It strictly dealt with the issue of whether or not the stop could be challenged under the Fourth Amendment. It did nothing more than say, under the Fourth Amendment's cost-benefit analysis, we're not going to apply the exclusionary rule in these administrative proceedings. It did not in any way limit any further arguments with respect to the implied consent statutes or what could be raised in an administrative hearing. Now, when you look at 321J13 sub 6, that's the legislative enactment that you just referenced. And what that legislative enactment did was it broke down the barriers between the criminal proceedings and the administrative proceedings, thereby undermining the rationale and the holding in Westendorf. Because if we look at Westendorf, it was a cost-benefit analysis in terms of we want to keep readily reliable evidence to combat the very bad evils of drunk driving, okay? Well, this statute did away with that rationale because it now allows the state and specifically the department to lose relevant evidence in a criminal process or in an administrative license suspension proceeding if, in fact, there's a judicial determination that that evidence was obtained unlawfully. So that unravels, in large part, the holding and rationale underlying the Westendorf decision. But aside from the deterrence, you also have to look at the purposes of the Iowa Constitution to provide a remedy. And that's the problem. Mr. Westra has no remedy. And it's easy to get sidetracked in, is this statutory, is this constitutional, how do we apply this, do we not apply this? But let's think about this for a minute. A DOT officer exceeded his authority, he broke the law, he effectuated a stop, my client's license was revoked because of it. and he has no remedy. That's the department's position. How can that be? It can't be. Our Constitution demands more. Our Constitution, relating back to 1902, says that we have to provide a remedy if there is an abuse of legal process. There clearly was an abuse of legal process here. There's no question about that. So what's the remedy? Remedy is reinstatement of the license. Without it, Mr. Westra does not have a remedy. I also believe that there's due process implications here, and both substantive and procedural due process was raised. And I'll take just the last 10 seconds here to identify that I believe we're talking about a fundamental right here. It's easy to say we're talking about loss of driving privileges, but in order to do that, you have to ignore the fact that the officer exceeded his legal authority to effectuate the stop in this case. I see my time's up.
Mr. Lindholm, thank you. Mr. Formaker.
May it please the court. Mr. Lindholm. Good afternoon. I'm Robin Formaker, and I'm privileged to represent the Iowa Department of Transportation in this case. As I sat at the council table just now listening to my friend Mr. Lindholm argue this case, really what I hear him saying to you is, look, my client, Mr. Westra, can't fit within the terms of the legislation that the Iowa legislature passed in Iowa Code Section 321J.13 subsection 6. It wasn't a complete breakdown, as he called it, of the barriers. It was limited. And therefore, I come before the court, Mr. Lindholm, and I ask that you find a new right under the Iowa Constitution and impose an exclusionary rule in the context of these civil driver's license revocation cases. I know I can't get it going into the United States Constitution because this court, as we've noted just a minute ago, over 30 years ago in Westendorf said there's no U.S. constitutional right that compels the imposition of an exclusionary rule in a civil driver's license revocation proceeding. So let's use the Iowa Constitution and let's come up with this right to do what the legislature declined to do.
Well, there are a lot of cases that go just that way in other states, some that don't. It certainly depends on, I think, number one, is there a constitutional right involved? And Justice Mansfield was working on the notion that you heard that okay, there was a lack of authority here. I think you concede that, maybe you don't, but I should ask you in light of our case law, the arresting officer lacked authority. The question could be posed. Why don't you answer that question first?
Justice Appel, under the holdings of this court in Rylea and Werner, the arresting officer would lack statutory authority. There's not a constitutional issue here. I'll be happy to expand on that further. But it lacked statutory authority to issue criminal citations. And I understand where you're going with the question, but I also would like to call to your attention, because I think it's pretty confusing out there in terms, with all due respect to the court's decisions. Yeah, very good, very good. That's why I'm happy to have this opportunity. Under Rylea, this court also said, look, if an officer has received the training required in Iowa Code Chapter 321J and has received training and is certified in the implied consent processes, and the record in this case shows that was the case with respect to Officer Wilson, then in Rylea you said, well, they may enforce the Chapter 321J provisions. Now, I would say at least, so we don't get into quibbling about the criminal sphere, but at least with respect to this civil matter, because this is a civil matter, I would say he's authorized to stop and make the implied consent procedure and apply it. And we've asked in the brief, we just had a couple paragraphs on it, we didn't devote a lot of time to it, but we argued that below, and I think that's an alternative grounds for affirmance. Because quite frankly, look, when we're talking about exclusionary rules, we're talking about the stuff normally that's in the criminal realm, okay?
Oh, but wait a minute. Whoa.
Well, I said normally.
Well, if you look at Lefebvre, there's a footnote that has about 42 civil contexts from various immigration cases to forfeiture cases. It goes on and on and on. But I do agree with your basic point, which is if indeed the officers had full authority to do what they did, there's no constitutional issue, of course, involved.
And there was no constitutional adjudication in Rylea or Werner either. That was a matter of interpreting 321.477. And the footnote that you talk about cases, I don't see that authority here in the Iowa cases, Justice Appel. In fact, you raised forfeiture. Forfeiture has been deemed to be quasi-criminal. And that's quite a bit different because the property seized might be of such a value that it would exceed perhaps the fine that you might get in a criminal matter. That's a different breed of cat. But typically, normally, generally, if you'll accept that, you don't have exclusionary rules in civil license revocation proceedings. And I'd say, too, let's think about this proceeding now we have in Iowa and what the statutes provide. Okay, I haven't convinced you on that. Let me go to another argument. Let's talk about 17A.18 subsection 3 and the fact that the burden in these proceedings is on the licensee. There's no burden. This is an unusual kind of civil case because the burden is not on the government. The burden is upon the licensee. And it just strikes me, maybe it's just me, it just strikes me as a little bit peculiar to think that the party that has the burden is now going to be awarded with an exclusionary rule, and they can show up at the administrative hearing and say, good afternoon, I'm the party with the burden, but now I've got a sword to use with an exclusionary rule, and though I have the burden, I'll exclude from evidence that this court in its past decisions has said, look, it's best if DOT have all the best reliable evidence before it to make the important determinations about licensing. You know, with 321J.13 subsection 6 on the books as well, I would ask, I read this differently than Mr. Lindholm. He says, well, that is proof that we've eroded Westendorf. Quite frankly, I look at 321J.13 subsection 6 and say, that is proof that this is not a good candidate for this court to suddenly create an exclusionary rule. It's not like the legislature's been tone deaf to some of the concerns he's raised. They passed a provision, 321J13 subsection 6. They linked its application to a criminal prosecution in the OWI charge. That's their job and their duty and their prerogative to define the scope of the statute. That's not the court's job. And they did not extend. Tager makes it clear. It's not, I think the word incomplete was used. That's fine. That's for the legislature's determination, not this court. But they didn't extend it to Mr. Westra's circumstance. But the fact that the legislature has acted in this arena suggests to me, I mean, he makes this argument, I wrote it down, that if you don't give out an exclusionary rule here under the Iowa Constitution, he says there's going to be, this is going to fail to promote the integrity of the judiciary. Well, I don't follow that for 1 second.
Well, I do if it's a constitutional.
It's not constitutional.
Well, I understand, and I do understand your argument that the first question is it a constitutional question or not? And you say no.
Clearly it's not.
Well, I'm not so sure of that. But anyway, if it's purely a matter of statute, then your argument is that, well, I mean, they covered half of it and didn't cover the other half, and therefore the legislature has made its judgment.
Well, Article 1, Section 8, Article 1, Section 9, they don't even appear, to my knowledge, in either the Rylea or Werner opinions. Those were cases that Justice Mansfield wrote the opinions on that talked about 321.477 and said, well, these DOT peace officers, despite the fact they're peace officers, are not supposed to be writing citations prior to the amendment outside the scope of these categories, which weren't, frankly, addressed in the case either. It just didn't happen to be the vehicle to address them, but the categories of operating authority, registration, size, weight, and load. Those are actually rather broad categories, at least operating authority is, but that would be for another day. But under 321J.13 subsection 6, it just seems to me that makes it a bad candidate here for this court. When you're talking about judicial integrity, and this is my take on it, with all due respect to the court, it's my take on it. When you got the legislature, the people that get voted in the office over here to pass the law, and they enact a law, 321J13 subsection 6. And by the way, it's not just that statute. Take a look at 321J.20 that they just amended last July 1. We addressed that in our brief. You've got very broad authority now, these folks that are revoked, to go out with an ignition interlock device and get a temporary restricted license and frankly drive around pretty much with the same freedom that you or I have. So the legislature's acting in this arena, and I don't think it promotes judicial integrity if all of a sudden, when you've had 3 decades of jurisprudence under Westendorf saying, look, in the absence of the legislature acting, we don't consider matters of the legality of the stop in the implied consent proceeding. That's what Westendorf held. That's what Morgan held. That's what Ludka held. There's a whole host of cases. And then all of a sudden, this court, even though the legislature is operating in this arena, says, you know what? We just discovered a right in the Iowa Constitution. That's the law now. Now, it seems to me that's the sort of thing that makes people say, why do I vote for the legislature if the court can create this after this period of time when we've been told, look, this is an arena in which there's an exclusionary rule. It's not best applied in this particular arena. And I would also, if you're going to get into the constitutional analysis, let's take a look at the background of which these cases come up to the court. This court has time and again said that the purpose behind 321J is to protect the public from the evils of the drunk driver. In fact, this court, going back to the 1960s, if you go back 50 years and look at your cases, this court's used, I think, some of the strongest language I've seen. You have said repeatedly that the purpose behind Chapter 321J is to reduce or rid the roads of the Holocaust.
Well, it looks like you're saying that the power of judicial review doesn't rest with this court and that the legislature can trump it, and that's just not the case. In fact, you're pushing me almost in the other direction. The court has said repeatedly under Article 1, Section 8, where there's a constitutional violation, and I understand your argument there, but where there's a constitutional violation, the courts of this state are not going to entertain the evidence because it taints the judicial process. And that's what the United States Supreme Court said for 50, 60, 70 years, and that's what our ancient cases say, that the Haight case and other cases say earlier. But if indeed what we're dealing here with is solely a question not of constitutional dimension, but simply a question of statutory authority that's not constitutional, then some of your statutory interpretation arguments have some sense to me. Do you have case law that suggests that when an unauthorized public servant who is not authorized to engage in stops or the equivalent, do you have case law that suggests that that doesn't give rise to constitutional violations?
In the context of the implied consent proceedings, the case law is that whether it's constitutional or not is immaterial. That was the words of the Court of Appeals in Morgan. And may I address what you said earlier?
To say it's critical to me.
Sure, I'd like to address that.
So to me, I would like to hear your best argument that says that the lack of authority does not give rise to a constitutional claim where there is a stop. And so
I think it flows right out of Westendorf. It flows from Westendorf and its progeny. Flows from Morgan. Flows from Lubka. And I'm not saying that this court doesn't have the power of judicial review, but I think it should be used sparingly. And I'm responding to this contention that if you don't grant an exclusionary rule, there's going to be this sudden diminution in the public's perception of the integrity of the judiciary. It was the judiciary that said, look, there's no exclusionary rule here, and it's best if DOT have the reliable evidence before it on the issue of intoxication, even if it is evidence from an unconstitutional stop or evidence from a matter that would be inadmissible in the criminal proceedings. I mean, to get back where I was going before in terms of the constitutional analysis, Justice Appel, think about what this court has said.
I think the answer to my question is no.
The answer to your question is I have the case. The answer to your question is that the cases under Westendorf, I think, make it quite clear that in the context of an implied consent hearing, you don't take that up. The legality of the stop is not something that's taken up.
I agree with Justice Appel that this may well be an important question. That is, if you have a DOT officer who's coded with the authority of law, but the statute doesn't happen to give him legal authority to make traffic stops, as appears to have occurred in this case, is that a constitutional issue, assuming there was reasonable suspicion, there was a traffic violation committed in the officer's presence? Is that a constitutional issue, or is it just a statutory issue? Do you have authority on this, or
Yeah,
that's something we should look into ourselves.
First of all, I think it's statutory, based upon the way you ruled in Rylea and Werner. You said that under 321-477, they didn't have the authority. Furthermore, at the time of this stop, on May 9, 2017, those cases hadn't come down. I would argue there's no constitutional violation based upon what this court came up with last year in answering certified questions from the federal court in the Baldwin case versus City of Esterville. Because I would argue, and we'd be prepared, it's outside the record of this case, but if you want to put me to the test of the proof, I'm prepared to say,
I want to hear about some case law.
that's what I'm giving you. I'm giving you Baldwin versus City of Esterville because I would be prepared to prove under the parameters of that decision, Justice Appel, that these officers conformed their conduct to due care at all times as to what they thought the law was. They had received the advice of counsel from the Iowa Attorney General in a 1990 opinion that told them they could act with respect to offenses that occurred in their presence. We had decisions from courts throughout the state. In the Werner case, for example, I realize you ruled against us on appeal, but if you take a look at that case, that came out of the 6th District with a district court judge that said, look, you not only have the power to make arrests for offenses committed within your presence under the Citizens Arrest Statute and State v. Lloyd, but because they're peace officers, I believe you had general arrest powers. Now, you had judges and lawyers that weren't agreeing on this. We had the advice of counsel from the Attorney General in 1990, and I think that shows, and DOT requested that advice, that shows DOT acting with due care to have these officers conform to the law. And under Baldwin, which
Didn't we reject the good faith exception exclusionary rule in Klein?
you did in the criminal prosecution in Klein, but as I read Baldwin, Justice Appel, you've said that in that Baldwin even involved allegations of violation of Article 1, Section 8.
That's a plaintiff's claim.
That's a constitutional tort claim. And
Plaintiffs are trying to get money from somebody.
yes, and you've said that that's a defense to an allegation that there was a constitutional infraction committed, that if the party and the officer pleads and proves that the officer had conformed the officer's conduct to due care to follow the law, that's a complete defense. So it seems to me,
Claim for money.
I beg your pardon? I'm sorry, I didn't hear you.
I'm sorry, I'm pushing the button off and on, I guess.
Okay.
Yeah, that case involved a effort by a plaintiff to get money out of somebody. It was a offensive action, not a defensive action like we have here.
Yes, but it involved the accusation that there'd been constitutional infractions. I think that's why that's significant. The statute in this case, 321J 13 subsection 2, limits the issues in the implied consent proceedings, and the case law that I've seen from this court through the years indicates that the matters pertaining to the stop are not to be taken up. And other than in the realm here where the remedy was conferred in 321J 13 subsection 6, I would ask this court to apply the law as it's been handed down for the last 3 decades and affirm the revocation of the driving privileges as was decided by Judge Gamble in the court below. Unless you have other questions, I think my time is up. So I thank you so much.
Mr. Formaker, thank you as well. Mr. Lindholm, you may present your rebuttal.
Let's not forget what implied consent is. Implied consent is a statutory scheme that allows an invasion into the integrity of somebody's body. We know that it's protected by both the Fourth Amendment and Article 1, Section 8 of the Iowa Constitution. A breath test is a protected privacy right. We know that from Petty John.
I want to jump back with something regarding that. You made a comment earlier, and I didn't want to keep you over. I knew you were coming back up. You've talked a bit about 321J.13 subsection 6 and using that as an argument that we're already moving in that direction by having a district court allow, but through a finding, then that can affect the administrative proceeding. Could it be, instead of for the reasoning you're saying or as a justification, that kind of tells me when you have a criminal proceeding filed, you're going to have 3 sets of eyes. You're going to have the defense attorney's eyes, of course, the court's eyes, and the administrative. So you're going to have the administrative proceeding knows there's something going on. There's a court proceeding, due process. All of those things will be handled. When there is no criminal filing, then the DOT is just between the DOT and the driver, correct?
Yeah,
So
I
there's
don't
nothing else
think-
for them to lean on as far as any review of the illegality or whatever it may be?
I think I'm understanding your question. I don't think there's any interplay and knowledge, at least that I'm aware of, on the part of the administrative law judges and district court judges on whether or not there's a criminal charge pending or not.
Well, just the fact legislatively that they allowed there to be that give and take, isn't that an indicator that it's perhaps because there is a review of that incident, and they will therefore give the district court some weight and allow that finding to be used in the administrative proceeding? You seem to be arguing that because my client doesn't have a criminal charge, he's treated unfairly. But my point is, isn't it also true that without that criminal charge, we don't have the due process of a trial or a hearing for the administrative proceeding to rely on?
I'm not entirely sure I understand your question, but I'll try to answer it. My position is that Mr. Westra was brought in, implied consent was invoked, and it was all done as a result of an officer who exceeded his lawful authority, broke the law to get to that point. My position simply is that there is no criminal proceeding. He therefore does not get the protections of 321J13 sub 6 and is left without any remedy whatsoever. That's my position.
What's your response to the state's alternative ground to affirm that this particular DOT officer was trained and had authority to conduct a 321J investigation?
That's the same argument that they raised in Werner and was rejected. They attempted to justify the officer's actions in Werner on the fact that the driver was suspended, and there was no evidence that the DOT officer knew Werner was suspended at the time. The same holds true here. There's no evidence that Mr. Westra was intoxicated at the time the officer effectuated the stop. So that argument doesn't hold water. Let me jump back to the constitutional issue. Implied consent. It is a statutory scheme that allows the state to invade the integrity of the human body. We know it's protected under Article 1, Section 8 from our holding in from this court's holding in Pettyjohn. Implied consent has been said to be an agreement between drivers and the Department of Transportation for use of the roads. Do those drivers give up their constitutional rights simply by getting in the car and driving? That's what the department is asserting, is that there is no constitutional protections here if we're simply talking about the suspension of a driver's license. If that's the case, doesn't that unravel the whole agreement framework of the implied consent proceedings? The answer's got to be yes, it does. Because that agreement holds no water if the people of Iowa check their constitutional rights at the door when they're handed a driver's license. That's why this is constitutional. That's why Mr. Westra's constitutional rights were violated when this officer exceeded the scope of his authority and effectuated the stop. All I'm asking is that this court provide him a remedy. That can be done one of several ways. It can be that the Iowa Constitution allows for the application of the exclusionary rule, which we've given you good basis to do. It also could be that there is inherent in the implied consent statutes the requirement that an officer act reasonably. That's exactly what Vermont did, or constitutionally. That's exactly what Vermont did in the Lucier case. They said this reasonable grounds requirement of the implied consent statute presumes a valid stop and valid arrest. It's easy to get there. We're just asking that he be provided a remedy. Thank you for your time.
Mr. Lindholm, thank you as well, and Mr. Formaker, thank you again. Case of Westra versus Iowa Department of Transportation has now been submitted. We'll next hear the arguments in Albaugh versus the Reserve.